based on a recognition from the legislature regarding an uptake in the frivolous filings by inmates within the state of Florida in order to save state and judicial resources. Based on the statute, this court should order the trial court to apply subsection 6 to Mr. Allen's complaint, a second amended complaint in this particular case. Because petitioners have filed a petition for writ of mandamus rather than an interlocutory appeal, there's 3 elements that must be met by the petitioners in order for the writ to issue. Specifically, petitioners are required to show a legal right, a corresponding indisputable and ministerial duty on the part of the trial court to act, and then finally no additional remedies available, no legal remedies.
And I'm going to ask you about the legal remedies in a minute, but when I was first looking at this, I thought that perhaps there was error by Judge Gievers in not applying the 2 binding cases, which you cite, Reed and the other one. But then in looking at it further, her order on defendant's motion to dismiss amended complaint, which led to the second amended complaint, didn't actually dismiss the complaint like in Reed and Mims, but it just ordered basically a repleading, like she doesn't cite the more definite statement rule, but it seems more like a more definite statement than a dismissal and a new initiation of the pleadings process. So how then does 570856 apply here if a new whole case has not been initiated like in Reed and Mims, when she just orders the pleadings that were poor and still are pretty poor, frankly, to be cleaned up? Well,
under the Florida Rules of Civil Procedure, a case is initiated when there's a filing of a new complaint. The action by Judge Gievers in this particular case acted as a dismissal of that complaint because the plaintiff could not rely on that complaint that was previously filed. And case law is pretty clear. It's established law that when you file an amended complaint, unless there's an intention to preserve previous portions from that complaint, it supersedes the original complaint. So the requirement that he file an amended complaint in this particular case, and then the filing of the amended complaint acted as a new judicial proceeding under the statute. So the argument would be that based on the Florida Rules of Civil Procedure, as well as the well-established case law, that the judicial proceeding was the filing of the amended complaint required by the court, because the dismissal of that original complaint...
Well, it wasn't dismissed, though. She specifically denied dismissal there, which seems to me to potentially take it out of Mims and Reed.
The petitioners would disagree because of the Florida Rules of Civil Procedure specifically stating that even if a judicial proceeding is not defined within the statute itself. So you would have to look to other ways of defining defining it. One way to define it is under the Florida Rules of Civil Procedure, as well as the corresponding case law related to amended complaints. Another way would be to turn to look at a legal definition of what a judicial proceeding would be. Legal definition, according to Blacks, would be any court proceeding, any proceeding initiated to procure an order or decree. In this particular case, the amended complaint is trying to procure an order or decree in his favor. So the filing of the amended complaint as ordered by the court would not necessarily take it out of the purview of Reed versus Mims, as well as Gorel.
Is everything moot now that summary judgment motion was apparently heard by the trial court?
No, Your Honor, it's not, for 2 reasons. First, the issue squarely before this court is whether the application of subsection 6 was appropriate in this case. That's the issue at issue in this case. Now, Judge Gievers did in fact rule on a motion for summary judgment. However, this court has actually issued a number of opinions recently related to sovereign immunity and the lack of jurisdiction to hear sovereign immunity claims for interlocutory appeals. Specifically, the case that started it all actually was decided by this court in FHP versus Jackson. The citation is 238 Southern 3rd 430. In this case, there still remains a sovereign immunity issue because the court, as a matter of law, has not determined, and it's unclear whether the court, as a matter of law, has determined whether sovereign immunity even applies to a couple of the defendants.
But at the same time, the court in the summary judgment order has clearly said there are factual matters relating to malicious prosecution, abuse of process, bad faith, and things of that matter. And if we look at the purpose of 57.056, it's to screen out those complaints that aren't proper against the state and its employees. So can you address why that finding didn't cure the deficiency under the statute?
It may have cured it with those particular issues, as the court has stated, with the failure to state a claim issue under and those particular claims. However, the sovereign immunity issue still remains, and that is clearly within the purview of subsection 6. That is subsection B of the statute that says if a defendant is being sued and is entitled to immunity.
But don't some of those issues go to whether the defendants are entitled to sovereign immunity?
Well, the way that the complaint is written and the second amended complaint is written is it's intentional torts against individual officers. There's no mention of negligence within the complaint itself. So the only claim that could be pursued against the secretary, according to 768.28 subsection 9, would be a negligence claim. There is no negligence claim in this case, so possibly, well, at least within the amended complaint, the second amended complaint. So the issue becomes, is the secretary and the warden in this case, under a different subsection of 768.28, entitled to sovereign immunity? And that is undecided as of this point, because there's no opinion in the order written about whether or not, as a matter of law, that issue has been decided.
Well, let me focus you on the third prong of mandamus and no other legal remedy. In your petition, you don't even cite any cases in that regard. The judge's November 3rd, 2017 order gave each side 30 days, so he amended the complaint late, frankly, but did amend the complaint on December 19. And then the defendant petitioners here didn't respond. They could have answered. Mm-hmm. They could have moved for summary judgment. They could have moved for judgment on the pleadings. They could have sought to compel a determination as to the application of the statute, but they did nothing within the 30 days. And then, in fact, in the a case management conference was set where she warned the defendants need to do something, and they still delayed in doing something until the time for trial was very compressed then. So it seems to me that there were a number of potential legal remedies that were available to defendants that they didn't avail themselves of.
Well, the issue was the defendants actually filed an answer on the date of the case management conference, which was, I think, March 1st, 2018 of this year. And then on that particular date, the judge Judge Geaver set the case for trial on that date. The defendants objected to that specific setting of it because of a number of issues related to undersigned counsel's calendar with other cases. Just because the defendants did not file a motion for summary judgment or a motion to dismiss in this case does not alleviate the requirement to apply the statute. Specifically, that's addressed in MIMS.
Well, I potentially agree, but wouldn't you have had an adequate legal remedy had you moved to dismiss, had you timely moved for summary judgment that would take us out of mandamus then?
I would say no, Your Honor. The reason why is because this case is an indicator of why subsection 6 is very important. Because what happened in this particular case is the defendants filed two motions to dismiss. The original complaint had 6 claims. Second complaint, the amended complaint, had 20 claims. Third complaint now has 50. In each of the previous motions to dismiss, the trial court either denied the motion to dismiss or granted it in part and provided the plaintiff leave to amend. So strategically, the decision would have been made was made by the defendants to file a motion for summary judgment and proceed through discovery. The issue was that on the date of the filing of the answer, so yes, it was filed late, but that on the date of the filing of the answer, the judge set an extremely tight timeline for discovery, to the point where the the summary judgment motion, the very last day of the summary judgment motion, according to the Florida Rules of Civil Procedure, would have been the 30th day of discovery, and anything later than that would have been untimely.
But instead of filing that answer on March 1, couldn't the defendants have filed a motion to dismiss at that time to seek to dismiss the second amended complaint? At some point then, a judge doesn't have to grant leave to amend. She dismisses it yet again, and maybe the department at that point says, I think dismissals with prejudice is appropriate. You've given, plaintiff now 3 times to try to plead. He can't plead it.
Well, yes, Your Honor, that could actually
So
happen.
why is there then a unavailability of a legal remedy? You had a legal remedy on March 1, but you answered instead of moved to dismiss.
Well, the legal remedy for this particular appeal, that's what I guess the legal remedy refers to. There is no legal remedy with this particular appeal because of the fact that there's no basis for an interlocutory appeal in this particular case. The only way to get it in front of this court and require Judge Gievers to apply the statute would have been to file a writ of mandamus. That's the legal remedy. That's the lack of legal remedy in this particular case because there's been no decision. There's been no order that's issued that says that that subsection 6 does not require an amended complaint in this does not apply to amended complaints in this particular case.
You raise an interesting point. Does 578056 require an order? I think it just requires screening. Is a judge required to say, I have screened this and it passes muster under 578056?
I don't know. The statute itself does not require an order stating that. However, there would need to be an order indicating to the defendants at least, stating that the statute does not apply. In this case, that has not happened. There has been no order stating that. The decision made by the trial court was at a hearing in which the trial court indicated that that the statute does not apply, but there's been no issue, there's been no order, no appealable order indicating that in any way, shape, or form. Now, this case is ultimately the issue with this case. What it deals with is defendants are not trying to foreclose the plaintiff from filing a case. We are trying to limit down the claims from 50 to a reasonable amount. Defendants have said from the very beginning that there may be a claim which could survive a motion to dismiss on this particular case. But the issue is that each of the complaints, even though they were dismissed, were further amended with additional claims. And because of that, the defendants would request that this court order the trial court to apply subsection 6 to the statute and determine whether or not specifically sovereign immunity were to apply to the defendants as a matter of law. Thank you.
May it please the court, James Cook for the plaintiff, the appellee. I think that first of all, the court should keep in mind the liberal construction that is due to be placed on pro se pleadings. Our perception is that the trial court in this case, discerned the elements of causes of action in the original pleadings and chose not to dismiss it on presentation by the defendants that they were not sufficiently on notice of some issues. She granted the motion to dismiss. The complaint was recast, and ultimately it stood up against a motion for summary judgment on all the issues, including summary judgment, which in this case was a fact question. The initiation of a proceeding, I think, has to be when a case first comes to the court. It's not with each new amended complaint.
Well, that's contrary to what the other DCAs have said and what would have been. I mean, we can disagree with our colleagues at the other DCAs, but Judge Gievers respectfully is not permitted to do that. Reed and James would seem to be binding on her, right?
Yes, Your Honor. However, those were both cases that were in an ex parte posture at the time that the court applied that statute. And when Judge Gevers, and I believe Judge Gevers did apply the statute to the initial round, and when the defendants were represented by counsel and had filed a motion to dismiss, then the matter was in, I think, a different posture than with either Reed or Mims. I think in each of those cases it was in an ex parte posture in a practical sense.
What difference does that make in terms of applying the plain language of the statute to the trial court's mandatory duty to screen the complaint?
The court has a mandatory duty to screen the initial complaint. However, I think that at subsequent amendment, it says may, and so I think the requirement is only as to the first complaint, and that is the complaint at the ex parte stage. Now, of course,
Counsel, when you say may, you're jumping down to subsection 8 of the statute as opposed to subsection 6 of the statute, correct?
I believe that's correct.
I mean, logically, under your construct of the statute, a plaintiff can just get by on the first screening and then do whatever he wants. I mean, arguably reinsert dismissed claims. How does that give effect to the purpose of the statute if there's no screening of any subsequent complaints?
Well, I think that the statute is meant to screen complaints at the stage, most specifically meant to screen the complaint at the stage when there is no adversariness. I think that although the statute envisions the adversary process as taking over from that point, it does give the court the freedom to dismiss a complaint sua sponte if the court feels that it's not, doesn't state a cause of action.
But under your logic, then, in the amended complaint, the plaintiff could add 15 more state official defendants, and they would have no due process right to the screening under the statute. Is that your position?
Once there is adversariness, I believe that is correct. I think that all of the courts, I think, have made clear that the initial stages of the judicial process are greatly aided by adverse counsel. And so I think that the perceived problem of an uptick in prisoner complaints, which was actually just an effect of mass incarceration, deeply required an initial screening. But I think that the adversary process was deemed to be sufficient, although it gave the judge the ability to step in and say, no, this complaint doesn't go.
What, if any, impact does the fact that the judge has now had a hearing on the motion for summary judgment have on the mandamus petition before us?
I think it moots it. I think every single claim by the defendants was either met, they had unusually full opportunity for argument, they were given a follow-up presentation as we were, and each of those issues of factor law were dealt with, and some of them were actually withdrawn by the defendants.
Could you address the appellant's argument that the trial court's failure to address the absence of a negligence claim greatly affects the decision on whether the appellants are entitled to sovereign immunity? There was no order on and no ruling on that point.
Well, I think that there was an oral pronouncement that the court would imply an action for negligence as to the secretary. And if that didn't get into the order, it's definitely in the transcript. But there again, it's the exercise of the liberal construction that the court is permitted to take on the pleadings.
In the abstract, do you want to go to trial on this second amended pro se complaint? I mean, don't you want to clean this up at some point, or?
You know, when I first looked at it, I thought that there were a number of defects, but as I looked closer, it was simply inarticulate. The pro se plaintiff, whose prior case before this court clarified in our favor the issue of pre-suit notice, actually put a lot of thought into that. And I believe that we're entitled to preserve the liberal construction of his pleadings. And so I'm not sure, of course that would be his decision, but I'm not sure it would make matters, I think everything has been clarified in the crucible of the hearings that we've had. I would just say that I think that the judge's power to construe pleadings, to look at a pattern of facts and discern a pattern that states a cause of action is an extremely important part of our law. And I like the presentation that was made, the representation that was made in Barrett versus City of Margate, where it says the pro se litigant must set forth factual assertions that can be supported by evidence, which gives rise to legal liability, and that's at 743 Southern 2nd, 1160, and the page here is 1163. I think that states the plaintiff's claim, and I think that's basically what we rely on. I think that all of the issues that could have been raised in a judicial review, which could have been done sua sponte, the law allows it, but doesn't require it, have been subsequently answered in a fairly substantial hearing on summary judgment, at which the defendants were allowed to bring all the evidence that they had accumulated, and we were allowed to respond. That said, if there are no other questions, I think I would rest.
Judge Kelsey said something that was extremely important. The interpretation that Mr. Allen wants of this statute would lead to an extremely absurd result, in that the plaintiff could file something, get that okay, then amend the complaint immediately, and there's no further screening of that. That leads to an absurd result because, according to the court's interpretation as well as Mr. Allen's interpretation, that would just prevent the court from screening it in any way, shape, or form. And as I described, the screening provision was extremely important in this case.
Getting to the mootness issue and the adequate remedy law, Appley argues that the court has implied or found there to be a negligence action implied in the complaint against the secretary, which moots out that issue of whether sovereign immunity was properly denied.
That may be the case, but the problem is that the order itself doesn't use the magic words as referenced by this court in Jackson of as a matter of law. So the defendants would be denied the ability to possibly file an interlocutory appeal to this court.
But you could file an appeal. We'd cite to Jackson. Jackson's up at the Supreme Court right now. Ultimately, presumably they're going to resolve it and tell us whether we and the third DCA in the related case are right or wrong, right?
That is correct, but the issue is that the defendants in the meantime would have to go to trial on an issue where there may be sovereign immunity on. That's the problem.
You go to trial while the interlocutory appeal was pending.
Well, we wouldn't have a basis for the interlocutory appeal because you would have no jurisdiction. That's the ruling in the Jackson decisions. The Jackson decisions and the decisions that follow indicate that there's no jurisdiction for this court to hear without that magic language. Thank you.
Thank you, counsel. Thank you both. This court is adjourned.
All rise.